Islam Hotep, Shalom Mishkael, peace to the gods, peace to the goddesses. Peace be upon you, my sons, peace be upon you, my daughters. I reserve all my rights without recourse. On this sunny Saturday, sitting by the pool a little bit. Want to read a little bit of the Arbitration Award. Final Arbitration Award. Breach of violation of required contract terms. Alright, so this is pretty thick. This court document is 20 pages, and then the summarization is looks like 6 pages, 5 or 6 pages for the summarization. So see how much that I read of it. And I'll change the names just because. Alright, Final Arbitration Award. It starts out with the heading, the claimants. We're the claimants versus old Brucey Bruce over at the UPS store, and their CFO for breach of contract. Alright, the parties have agreed that a judgment of the court shall be entered upon the award made pursuant to the arbitration, and specify the court then at any time within 1 year after the award is made, any party to the arbitration may apply to the court so specified for an order confirming the award, and thereupon the court must grant such an order unless the award is vacated, modified, or corrected as prescribed in sections 10 and 11 of this title. If no court is specified in the agreement of the parties, then such application may be made to the United States courts in and for the district within such award was made. Notice of the application shall be served upon the adverse party, and thereupon the court shall have jurisdiction of such party as though they had appeared generally in the proceeding. If the adverse party is a resident of the district within which the award was made, such service shall be made upon the adverse party or their attorney as prescribed by law for service of notion of motion and action in the same court. If the adverse party shall be a non-resident, then the notice of the application shall be served by the marshal of any district within the adverse party may be found in like manner as other process of the court. Arbitrator's name, hearing location. The arbitrator, King Pharaoh, having considered the claimant's request for dispute resolution on complaint, finds the following. Jurisdictional allegations. This arbitrator has subject matter jurisdiction as acknowledged by 9 U.S. Code Section 129, 28 U.S. Codes Sections 1346, and the established common law, not limited to the following specifics: that and they put our name. It says, and that the respondents, and they put the respondents' names, have entered into an agreement whereby they knowingly and intentionally agree to the following: failure and or refusal to respond and provide the requested and necessary proof of claims shall be held in notice as agreed to by all parties, that a general response, a non-specific response, or a failure to respond with specificities and facts and conclusions of common law, and or to provide that requested information and documentation that is necessary and in support of the agreement shall constitute a failure and a deliberate and intentional refusal to respond, and as a result thereby and or therein, expressing the defaulting party's consent and agreement to said facts, and as a result of the self-executing agreement, the following is contingent upon their failure to respond in good faith, with specificity, with facts and conclusions of common law, to each and every averment, condition, and or claim raised, as they operate in favor of the claimant, through tacit acquiescence. Respondents not only expressly affirm the truth and validity of said facts set, established, and agreed upon between the parties of the conditional acceptance for value and counteroffer claim for proof of claim. Also, respondents have agreed and consented to respondents having a duty and obligation to provide the requested and necessary proof of claims, which has created and established for respondents an estoppel in this matter and all matters relating hereto and arising necessarily therefrom. And the above captioned matter was set for arbitration after the receipt of the application and dispute resolution complaint on June 10, 2019. And the arbitrator has notified all parties listed above. A copy of proof of notification is permanently affixed to this record by reference, granting each party the opportunity to submit documentations, records, proofs, evidence, exhibits, affidavits related to the instant matter, the contract, its terms, premises, promises, and obligations on or about May 2nd, 2019. And the respondents in the related action have made a claim against the claimant of this instant matter related to the claimant's interests and or properties. There exists a matter in dispute and or controversy associated with the contractual agreement, thereby extending jurisdiction to this body as per the terms of the agreement. A body to proceed as per the terms of the agreement, as well as relevant laws and facts in support as presented during the arbitration of this controversy. And the parties entered into a legally binding contractual relationship with each other, and this arbitrator finds that there is no fraud and or any attempt to induce fraud and or to commit fraud and or inducement of contract and or fraud in the factum